Hello, everyone, and welcome to this podcast on antisocial behaviour tools for registered social landlords. I'm Andy Moore. I'm a partner at MSB Solicitors and the head of antisocial behaviour at Leasehold. And I'm joined today with one of the other partners on our team, Philip Coburn.
Morning, Andy.
Morning, Phil. And I'm also joined with Andrew Fairman as well.
Morning, Andy. Hope everyone's well.
So we all work within our social housing team, and we all deal with antisocial behaviour on a day-to-day basis, really, don't we? In terms of the typical antisocial behaviour cases that we see, do you want to go through some of those with us, Phil? Do you want to start?
Yeah, I mean, quite often it will start with initial contact from the client, and there might be several months or sometimes years of background to it, or sometimes it might be an isolated incident that's happened that day or the night before. And if it's kind of nuisance over a long period of time, it might be noise from music or dogs or shouting. Isolated incidents can sometimes be attacks or sometimes very serious incidents. So the client usually needs urgent advice on what to do, and if that's, for example, an application for an injunction, that might be, well, should it be made without notice to the respondent, the person who's alleged to have caused the nuisance, or do you take a backward step and try and look at what's actually happened and gather the evidence and send everything off and put that person on notice to the hearing? Probably not at that stage looking at possession of the property, just a way of protecting those people who've been harmed or have had the nuisance or antisocial behaviour aimed to them. I think that's probably the initial thoughts that I'd go through.
Yeah. Andrew, to you as well. What do you see?
I'd say so. I think one of the difficulties, in particular, as we're talking about what tools there are available to use as well, is the varied nature of antisocial behaviour. Of course, you can, as Phil said, it could be a isolated incident, it could be a violent act in one sense, and we're very quickly dealing with an application that may go without notice, for example, as one of your available tools, or it could be a varied background of a whole host of different issues relating to basic noise nuisance. It may be that the incidents aren't necessarily that severe in isolation, but the accumulation of them over time can then cause significant difficulties for neighbours and complainants generally. So it's knowing what to use when, and that can be the difficulties in dealing with antisocial behaviour because of the varied nature of the issues you've got.
I think as well, too, over the years as well, I think some of the nature of antisocial behaviour has changed as well. I mean, more recently, we started to see, it was a first for me a couple of years ago. We had a fire in a property which was caused by somebody mining Bitcoin.
Yes.
That was a new one for me.
That's definitely a first.
A few years ago with that. And of course, more issues as well recently with neighbours fighting on social media as well, which has become a far wider issue. Then you police the internet as well as trying to police the streets when you're a social landlord, sometimes depending on that. And as well, for staff being targeted on social media. And it might be the organisation itself, tweets and Facebook comments being left about the organisation. But within that, sometimes as well, you see personal attacks on staff members too. So it's really, the range of antisocial behaviour has gone from, what we used to see in the past, which was issues on the streets and between neighbours, from noise nuisance right the way to cyber issues now as well.
That can give you good evidence though as well, can't it? So whereas traditionally you may not have had that, you've then got some hard concrete evidence often with social media these days that can help you in that application for an injunction, if that's what it is, but then it can also aid you if you've got staff members being attacked as well. You can tailor those terms of any injunction to suit those specific needs.
Absolutely.
As one of your tools available.
Then again, you've got the difficulty of who's behind a Twitter handle, haven't you? And
yes.
That can be difficult.
It becomes...
and also the lead off from social media is sometimes people get into messenger messages or other messages like WhatsApp and so on, and you need to be careful about whether you've got the whole picture or whether you've just got a snapshot of those messages where there's a threat and you don't necessarily know what the précis is to that.
Definitely. And messages could be deleted as well, so there's the issue with that. And knowing that full picture before you go in and trying to get that information from your complainant is very important, because you don't want to be, for example, if you've gone without notice on one set of facts and then to be presented once the defendant is served with that actually taken out of that context is an entirely different series of events.
Yeah.
can cause you great difficulties at any future return hearing.
So we've got a broad range of antisocial behaviour that we've got now, haven't we, in terms of that. In terms of our social landlords and their duty to deal with it, we know that it was 30 years ago now that they were dictated that they needed to create these policies in relation to antisocial behaviour to actually deal with it. And as part of that duty to publish policies, they got tools to be able to try and assist them in dealing with antisocial behaviour, because certainly for our private registered social landlords, the powers that they had at the start really were only eviction. That was it.
Yeah.
And of course, what we got 30 years ago is we got the introduction of 20 years ago, we got the introduction of injunctions, and that was a power that our social landlords use regularly now in cases when it's necessary for it. More recently, we've got the charter, the white paper, and the charter for social housing as well. So in terms of the duty, there's going to be further introductions in relation to that. Of course, it's not enforced yet. It's currently going through Parliament, but for the first time, really, our clients, our registered social landlords, are going to be targeted specifically on antisocial behaviour. So it's something that is incredibly important for them to deal with and to try and get to the root of it, isn't it?
Absolutely. And obviously they'll have to account to those statistics that they've got ultimately as well. So knowing what tools you've got available in order to try and deal with your antisocial behaviour is going to become extremely relevant, ensuring that your policy's tight on the antisocial behaviour grounds, and you know what actions you can take at the appropriate junctures as well is going to become quite important. Obviously, that white paper as well provides some further guidance that goes beyond the act that we've got in terms of the Antisocial Behaviour Crime Policing Act as well. So it presents an interesting new limelight for dealing with antisocial behaviour, when in reality the act itself is actually quite user friendly. It's reasonably well drafted. Everyone kind of knows where they are with it. The white paper may introduce some further elements that we're not used to having had in the last 10 years or so since the Act came in.
Absolutely. Phil, in terms of dealing with antisocial behaviour, before we get to the tools, at the basis of tackling antisocial behaviour, what should social landlords have in terms of policies and tenancy agreements?
Well, usually you'd expect there to be an antisocial behaviour policy, and not just have the policy, but know it and read it and understand it, and where we run off to court and make our applications, we don't want to be met with some response that a client's not complied with their own policy. So the policy may set out exactly what needs to be done. They should try and engage if it's a history of complaints like the noise nuisance or the banging. It's a bit easier to try and engage with the alleged perpetrator and try to look at things like mediation, acceptable behaviour contracts, and so on. That's quite difficult when it's an isolated incident and something's happened and it's very bad, and there needs to be some immediate protection in place. So it can't always be the case that you can comply with every single point that's in the policy, but certainly make best endeavours to and keep evidence of what you're doing and why you're doing it. So if you haven't complied with the policy, there might be a good reason why. Or if you have proposed something to a perpetrator or to a complainant and they haven't wanted to engage with it, then set that out, put it on the case notes. It might be important information that we need to put into statements. So they're the kind of initial steps they can take, but there might be a good reason for the behaviour. It might be related to a medical condition. When tenants are applying to take up a property, it might mention something about their health or mental health on the application. It's about offering support, not just because there's been a complaint, but support generally. But certainly where there's been a complaint that something's happened, I think try to avoid automatically assuming it's because they've done that thing on purpose and they've got capacity, they're able-bodied. There's no other reason why they've done this. And even where you don't have the information, you can still go off and contact a community mental health team, for example, ask if this person is known to their services, because they may not have disclosed.
It's interesting you mentioned mediation before as well, before you started going to the Equality Act, and there's a place for mediation, or at least some alternative dispute resolution between residents sometimes, and it's a sensitive subject approach. But when you're looking at the public sector equality duty, and of course, which is our clients to try and foster and advance the interest of somebody, particularly if they've got a protected characteristic, it is trying to build understanding between tenants, isn't it?
Yeah, and that mediation point is something that's worth looking into as well, because it may well be that you, using that lesser measure of mediation, actually resolves the issue that you've got between the neighbours, and that element of understanding is suggested. If there is, you have to obviously be careful what you do disclose to the other neighbours, but if the person with that protected characteristic is happy to discuss that with the complainants in a particular case, it may well be there's a compromise able to be reached outside of any legal process. And of course, that has cost implications as well as just good management of your antisocial behaviour, which can then be implemented as part of your policy and be reported on in those future statistics.
I know we've had it in cases before, haven't we, where there's been an agreement to disclosure by and an agreed disclosure as to someone's mental health issues they may have, and the experience that may create for them, so that neighbours can understand. Particularly, I'm thinking of matters where it might be where someone's been subject to a section in the past, and it might be an open section where they can go back on recall on that, which is in their best interest.
Yeah, of course.
That neighbours can play a part in spotting when somebody might be becoming ill again.
Yeah, absolutely.
Which is going to stop the antisocial behaviour potentially from forming at that point, or at its lower levels before it becomes to a greater issue, isn't it?
I think it can diffuse the situation, can't it? You could have, a complainant, and once they understand the reasons for behaviour, they themselves might say, well, they also have mental health problems, or they also have a disability, and it's easier for them to then understand the reasons why, or perhaps they're particularly sensitive to a thing because of their disability, and that can help the landlord to then put some support in place for both, not just one.
Particularly, as you say, if there is a specific thing that triggers it, if that specific thing can then be managed, or other residents, neighbours, complainants could be aware of what that specific trigger is. It may just be one simple thing, and if we can minimise the effect that's going to have, you may then be able to manage. And I think diffuse was a great word to use, because ultimately that's what we're trying to do here. You're never going to make it a perfect world, but if we can diffuse and minimise the scenarios where it's going to become a flashpoint, then that puts you on a good road to having a successful antisocial behaviour outcome, effectively.
So community buy-in can be one way that can assist us really in terms of that, and knowing that they are key partners really for our social landlords and trying to deal with things. You mentioned appropriate referrals earlier on to other agencies, and I think sometimes it gets, and it's a lot of the time it's in relation to budgetary and time constraints, but I know from the experience from a lot of our clients, it is that there's an awful lot expected from them as a housing provider. When, if you look at what their key job is letting homes and making sure they're decent homes and the communities are safe, etc. But at the core of it, they are a landlord. And so in terms of those referrals to other agencies, who should really be our clients' partners in dealing with that?
Well, you've got numerous elements to it, haven't you? And that partnership working across other professionals is where we want to bring that in, and whether that's adult social services, whether that's your community mental health teams, whether the police can assist, of course, whether you can obtain any disclosure from the local authority as well. All of those really are your best bet. And one option to try and manage it could be a sort of open letter sent across to all of those parties, so to all of those I've referenced, to say, look, this is the situation, this is what we're proposing to do. Are you aware of anything that we need to be aware of in order to allow us to manage our tenancy, to manage our stock better? And then from that letter, you've done one of two things. Either you've got that as evidence that you've tried to get that information, so you've tried to carry out the research as to any other factors that may be at play, or alternatively, you'll get the responses back, which will then help you manage that situation and be able to put in either the support that's in place, or adult social services, for example, may step in and provide some assistance in terms of a support system to minimise the behaviours that you're exhibiting, or maybe the same from the community mental health team.
That's it, and it's making sure there's that understanding, isn't it, with other agencies as well, so they actually know what we do. And
information sharing, without breaching data protection, information sharing, and that can sometimes resolve it. Everybody knows what the other person's doing. There's no finger pointing. It can sometimes be the case that the police will expect our clients, who you say, Andy, are landlords as a primary function, to go off and exercise policing functions, which they might have the power to do some of those things under the Act, but certainly the police have other and better powers, and probably comes down to a lack of resources for the police. It's just more pressure on our clients. But the adult social services is a good point. They can carry out a Care Act assessment. They can engage with families. They may not be professional carers. They might have carers who are family members, and maybe they can be engaged as well to find out what's going on. And quite often people haven't been assessed by adult social services, don't want to engage. But there's a fine line between what's a carer and maybe what's a friend who's just sat there not really doing very much and isn't prepared to help us.
Yeah. It's about having the right support in place, isn't it? Not just support for the sake of support. It's the right support to deal with the right issues, to resolve and, as we said earlier, diffuse the situation that you may have at hand.
Phil, you mentioned earlier acceptable behaviour contracts, and there's parenting contracts as well, which I've seen in the past. What role can they play in dealing with antisocial behaviour?
Well, I think at the heart of it, it's it can be a piece of paper, and it can explain to a person what is expected of them, albeit it may already be in the tenancy agreement. But it's a lesser measure. It's helping the tenant or the children of the tenant, as it may be, understand what's expected of them under the terms of their tenancy, or if it's a parent and child situation. Maybe it will help the child, depending on their age, understand what the possible consequences are that, if their behaviour continues, what impact this is having on their parents. If it's, the parents who maybe should be doing more things than they are, then again, it's focusing their mind. And again, although it's already in the tenancy, they should already be doing these things. But I think sometimes tenancies are, 20, 30 pages long, and probably not always read, I'd imagine, page to page. So having some bullet points down on a piece of paper, and in the tenant's mind, they've signed up to a contract, it probably is a bit easier to understand. We all like bullet points. We all like shortened versions of what's expected of us, because it's easier to process. So I think it's the main point really is something that's easier to process for the tenant, and understanding what they should or should not be doing.
And as well, I suppose that can give you a really good indicator as well, is if there's been some compliance with something like that in the past, that can be a good indicator that if antisocial behaviour is continuing sporadically, that maybe an injunction might be appropriate if legal action is required. Or if there's been none whatsoever, that might lead you towards possession proceedings as opposed to that, if there's been no willing whatsoever from there as well. Just moving on to legal options, and you mentioned the importance of lesser measures there, Phil. Lesser measures, Andrew, why is that so important for us to consider those?
Well, it's important in terms of proportionality. Of course, with your antisocial behaviour injunction process, you've got the consideration of the second limb of the test. The two limbs for seeking an injunction within Section 1 of the Act is effectively one that they're carrying out antisocial behaviour, which is, in the circumstances we're talking about, probably quite easy to make out. The second limb of the test is where it becomes a little more difficult, and that is that ultimately it's just and convenient for an order to be granted. And whether it's just and convenient is, of course, a question that's going to turn on each specific case. There's no sort of hard and fast rule for exactly what that is going to mean, and different judges may have different interpretations. But if there's an option for lesser measures to be taken, or those lesser measures haven't been explored or tried, it may well be that a court finds that it isn't just inconvenient to grant an order on those specific set of circumstances. Of course, in your more serious cases, you're unlikely to meet that. So it's got to be taken on a case-by-case basis, but it is something that's got to be given consideration to at an early stage, and that you're showing early intervention and attempts to deal with this outside of the court process, and that you have tried to intervene to restrict the antisocial behaviour without sort of just running off straight to court on the first issue, which may not be that serious in isolation necessarily.
Sometimes the lesser measure is the injunction, because if you're looking at possession proceedings, you're probably going to be asked, well, what lesser measures have you taken? And if you can show that you've already been to court and you've already obtained an injunction, and for whatever reason it's not being complied with, well, what's the alternative? Trying to commit that person to prison, which probably is more draconian than possession proceedings. So
definitely.
You know, it's showing that as well.
Yeah, there's an argument to be out there, isn't it? Whether to go to prison or not. Is it draconian or losing your home? But I think the other aspect of it as well, in terms of lesser measures, is that from a public law perspective, from an Equality Act and public sector equality duty perspective, and from a human rights perspective, if we are taking legal action which is going to be interfering with someone's liberty potentially, or their home, then it's really important for our clients, potentially as public bodies, that they've explored all of these other options as well, because that's, you know, when you get to court, your possession proceedings, you look into, or in your injunction, and you're looking to take that, then, you know, one of those key questions from the judge, and it's going to come up in most offences. I mean, the reality is that most of our cases are defended not on the facts. Most of our cases are defended on the Equality Act, public law, and human rights, aren't they? So it's so important to show that we've considered those lesser measures. And it's fine. I mean, if the ASB is so serious that we need to skip doing some of those things, as long as we've justified that.
That's the key word, isn't it? They're just justifying it, that justification, and being able to set out that you have taken those steps, that they haven't worked for whatever reason, and that's why it's then necessary and proportionate to bring that further action, whether it be your injunction proceedings, or if you're further down the stretch and you've tried the injunction, for example, and that hasn't worked, that kind of, it forms your justification for your possession proceedings then, doesn't it, effectively? That
I think when you're looking at proportionality as well, and you're carrying out those exercises, it's not just about how it's affecting the tenant, the defendant, the respondent, or what the impact is on them. It's looking as well and weighing in the balance the impact upon the complainants, the other residents. Maybe one person in a block of 20 flats, and the one person is causing antisocial behaviour, and it's affecting 19 more people. Might be vulnerable tenants, might be an over 55 scheme, you know, and weighing that in the balance as against the rights of one person, you might fall down on the side of 19. It's about looking at the impact on the client as well, how it's affecting their housing management functions, what time and resources is the issue taking up, and also the housing stock. If you have a tenant and part of their behaviour is causing damage or setting fire, whether on purpose or not, to their housing stock, that has a financial value, but also it's taking away housing stock from other people who are on a long waiting list. You know, it's a scarce resource, isn't it? Social housing. So it's weighing those things in the balance to demonstrate that you have considered everything. And it's easy for us to sit here and say, just do those things, but and sometimes it's so urgent that you can't quite maybe do all those things. But the proportionality it's a moving feast, isn't it? You're always considering it. So what you might not have done on day one of getting instructions, if there's then a return hearing, for example, in an injunction case, you'd expect to see some consideration of those things. And
it's right. And you say, in terms of demonstrating it, it's recording it and keeping note of it as well, because that's your evidence of it. And I often, you know, we get inquiries from clients asking about, you know, positions with legal cases, and they'll be thinking about it in-house, and unfortunately, until they go to take legal action, a lot of the time, they don't record actually really good evidence as they go along as to, we've decided not to take action at this point. And you only get really your first proportionality exercise or formal written exercise being carried out at the point they're about to take legal action, whereas they've had internal conversations and they've thought about it 10, 20, 30 times before, but no one's recorded actually at all of those points. That's them carrying out a proportionality exercise. And if they just keep a log of that at that point, and if they decided not to take action at this point and why, that in itself is fantastic evidence as to what's gone on before to them to get to that point.
And it could be something as simple as just note keeping of your thought process.
Yeah.
You know, it may be that you, as a experienced housing officer, for example, understand the position. This is why you've decided to take this action. Just having a note on that house file of that is why you've done it. It may well be a conversation you've had with someone superior, director, for example, or someone else involved in the process. It may be a co-worker you've had that discussion with. Just keeping that log of it on that house file as just a note, as an ongoing process when you are thinking about it, just writing it down can really help with that justification.
That's sometimes borne out in warning letters, isn't it? So sometimes the warning letters might not be very detailed, and there might not be a supporting case note about why just the warning was appropriate at that stage. But if you put it in the letter, it's telling the person why you've decided to take that step or not take, a more serious step. So, those kind of warning letters are really helpful, can be crucial sometimes. So, probably goes back to the ASB policy, doesn't it? That what does your policy say? It might say, send so many warning letters before you issue a final warning.
I suppose that comes into the procedure then, isn't it? Your warning letter, rather than it being a standardised warning letter which doesn't have much detail, it's having that section in there for you to really explain, as you say, why warning's appropriate in the circumstances and what we thought about it and what action we might consider in the future, depending on how the behaviour continues. Just turning on to our final two tools, really, which is our legal tools. So we're at the legal point now. It's injunction. We mentioned earlier about injunctions. So in terms of injunctions and what they are effectively an order prohibiting an injunction under the Antisocial Behaviour Crime Policing Act anyway is an order either prohibiting someone from doing something or a positive requirement in there as well to make them do something. In terms of injunctions that you've had in the past, Andrew, what kind of terms might be useful from a restrictive sense and also from a positive requirement as well?
Well, from a restrictive sense, obviously you can tailor it to suit what your scenario is. For example, if it resolves or relates to staffing issues or abuse of staff, you may have specific terms that the person is not to cause nuisance or annoyance, harass, be violent towards, threaten, or be threatening in any mannerism towards staff members. It may well be that you've got staff members in there, you've got other residents or other people with the right to occupy accommodation within the locality of the property of which your defendant ultimately resides at. You can also then have your specific clauses in there. For example, if it's noise nuisance, you may have a specific clause relating to noise not being audible and capable of causing nuisance or annoyance. And you may well have time restrictions linked to things. Other options, of course, you've got the option of an exclusion, rarely dealt with on a without notice basis, but there is an option to consider exclusions where you've got a significant risk of harm. And the crucial part of that test is having that significant risk of harm. In terms of positive requirements, the Act is actually quite good in having that within it, that you can have positive requirements. And I think when it was originally drafted, it was drafted with a good thought process that these could be really useful. Unfortunately, what we've seen in practice is they're rarely actually utilised and they're very difficult to obtain.
It's the supervision requirements.
Yes,
it is.
And
then it's quite strict in terms of the evidence in relation to supervision requirements as well.
Yes, it is. And it's obtaining that evidence and then having to have someone to police that element of it with a positive requirement that then ultimately leads courts not to want to grant it because you don't meet the evidential requirement, or people are reluctant to even attempt to meet that evidential requirement because of the element of that supervision going forward that potentially puts someone else as liable if that positive requirement isn't adhered
difficult
to
enforce, isn't it? It's quite
very
difficult.
So.
I think we've seen it with great positive requirement might be for a drug and alcohol service for someone to attend, but then when that drug and alcohol service are working with that person, the last thing they want to do is effectively be policing them unless because they're not under like a probation contract, for example, where they've they have a contract where they have to provide that service, and they have to report back to probation service in relation to engagement or not. It's different, isn't it?
Yeah, and it can often create a conflicted role then for that individual who's trying to manage that element in terms of looking after them to assist with their recovery if it is drug and alcohol rehabilitation program, for example. If they've then got to police whether they're actually attending it and report back to the court, it creates conflicts of their ability to support that individual in terms of that rehabilitation, whilst also trying to police whether or not they're in breach of an injunction order with ramifications potentially leading to committal to prison ultimately.
So it's a good tool if we can get all the pieces in place for it. It can be a really useful tool, but it is getting those pieces in place. And then filling in terms of possession and antisocial behaviour.
Yeah.
What are the grounds for seeking possession for antisocial behaviour?
So you can have discretionary grounds. You can have mandatory grounds. People may be more familiar with discretionary grounds. So ground 12 will be some breach of tenancy other than rent arrears, which has occurred. So that could be playing loud music. It could be that there's a dog in the property and the tenancy says don't have a dog. It could be that there's people staying in the property who aren't supposed to be there. Again, that's in breach. Ground 14, nuisance or antisocial behaviour. What's nuisance? It could be any number of things that cause a nuisance, but they're discretionary. So there can be mandatory grounds, which would be, for example, ground 7A. We won't really go into rent arrears grounds because we're talking about antisocial behaviour, but on the back of talking about injunctions, where there's, say, a breach of an injunction and it's been found or admitted, or where there's been a closure order, which the police have decided to exercise. Ground 7A is known as the absolute ground for possession. So where you're looking at breach of injunction, which is proven, that can be a condition under ground 7A. Where there's a closure order, that can be a condition. Where the tenant's committed a criminal offence and being convicted of it, and that conviction is known as a serious offence, defined in Schedule 2A Housing Act 85. You can go down the categories of offences and see if it's in there. Once you've, they're probably the most common grounds on antisocial behaviour, but when you get onto the mandatory side of things, you would think to some extent, well, there's a conviction, it's serious, the Act says it is, so, job done, that's it, but it's not that simple, and you get into the realms again of talking about proportionality, Equality Act, human rights, and those arguments can be raised by the tenant. And it all comes back to what we've already spoken about, justifying your reasoning. So why have you decided to use ground 7A? Is that a proportionate step? Does your antisocial behaviour policy or other policies say you won't use ground 7A or won't use mandatory grounds? Have you got a policy on what ground 7A is and how it's used? And again, if you can justify your reasoning for it, the tenant can still raise a defence. Even though ground 7A on the face of it's made out, it doesn't mean you'll get possession. If you look at grounds 12 and 14, the courts have got to consider whether there's been a breach of tenancy, whether there's been nuisance or antisocial behaviour. So is the ground made out? And if it is made out, does that mean it's so bad that the tenant's got to lose their home? So should it be an outright possession order? Should it be a suspended possession order? Is it adjourned on terms because there's been a long period of time between a last incident and when you finally end up at court? That the preliminary hearing might be 6 weeks after you issue proceedings, but if that's then put off and you end up at a trial, you could have 12 months of no antisocial behaviour, at which point you think...
and also from a landlord's perspective, that if the problem's solved, then you might not need to continue with your possession proceedings if you're at that point as well, isn't it? I mean, ultimately, we want to rent our properties. That's our job.
Yeah. So the service of notice and looking at possession and issuing possession proceedings isn't always meaning that the tenant is losing their home. And it's about, again, keeping under review that justification process, that proportionality of thinking, well, are we just going through it because we're in the process now, so we've got to get to trial and we've got to get a possession order because that was the initial aim. You've got to think, step back and look at it and think, is it still reasonable that we're carrying on with this? And the behaviour might be continuing throughout, and in which case it's quite obvious that it's.
I think that goes back to what you said earlier on, that exercise and considering proportionality is a moving exercise, isn't it?
Yeah.
It follows throughout the proceedings as well.
Yeah, definitely.
Yeah. So in terms of antisocial behaviour and the tools that we've got, that there's a pathway, isn't there, in terms of a staged approach you can take. And certainly when you look at injunctions, when you look at mandatory possession, there's a staged approach you can take in terms of starting engagement. So your policies, procedures, your foundations, your tenancy agreements, engagement with the tenants and the community, and then your interventions with the tenants all the way up to legal advice. But that's not to say that we have to always follow that staged approach, because depending on the behaviour, depending on what they're doing, depending on engagement, it might simply be appropriate to skip to a certain other part in the stage depending on that. And as you've both alluded to, it's just so important to justify the actions that we're taking, recording that, and dealing with that staged approach, really.
Yeah, absolutely.
So hopefully that's a good summary of the antisocial behaviour tools that are available, particularly considerations of Equality Act in the public sector, equality duty, public law. There's a wealth of information on our website. You can follow us on Twitter and on LinkedIn as well. There's more information on there. And if anyone has any queries, they can always contact us to discuss anything they've got. Thank you very much for joining me today, Phil and Andrew.
Thanks, Andy.
Really appreciate it. And thanks very much for watching this podcast as well. Thank you.